Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Some of you may recall several months ago I did a video on McElrath versus Georgia, which is a Supreme Court case that has recently been decided, and the Supreme Court decided it pretty much the way I thought they would decide it. And it's interesting because it was from a unanimous court. Everybody agreed that the double jeopardy provision applied here. And what is interesting is, among the excellent opinion from Judge Jackson, Concurrence by Judge Alito, where he points out something that I will discuss here in a little bit. But first, let's take a look at the opinion. So this is the syllabus where the Supreme Court's clerks tell you what they think the case is really about, and they summarize it pretty nicely. But I think the actual text from Judge Jackson is very good. Under Georgia law, a jury's verdict in a criminal case can be set aside if it is repugnant, meaning that it involves affirmative findings by a jury that are not legally and logically possible of existing simultaneously. And they represent that from the 2020 case. In this case, a jury found that petitioner Damian McElrath was not guilty by reason of insanity with respect to a malice murder count, but was guilty but mentally ill regarding two other counts, felony murder and aggravated assault, all of which pertain to the same underlying homicide. Invoking the repugnancy doctrine, Georgia courts nullified both the not guilty and guilty verdicts and authorized McElrath's retrial. McElrath now maintains the Fifth Amendment's double jeopardy clause prevents the state from retrying him for the crime that had resulted in the not guilty by reason of insanity finding. Under the circumstances presented here, we agree. Now, when they say that, that means that it's not a universal rule. It applies in the context of this case, and you have to be very careful about extending it to other cases. The jury's verdict constituted an acquittal for double jeopardy purposes, and an acquittal is an acquittal notwithstanding its apparent inconsistency with other verdicts that the jury may have rendered. So the case starts with a tragedy. Basically in 2012, when he was 18, he killed his mother. It was his adopted mother. She was a single parent. She'd struggled with caring for him. He had bipolar disorder. He was a mess. He went through psychiatric treatment. It didn't help. A few years before his murder, his mental health began to deteriorate substantially. Not that it was any great shakes to begin with. Basically, he was hospitalized. Clinical staff believed that he was no longer a threat to himself, and then a week later he stabbed his mom to death. After law enforcement arrived at the scene, McElrath was taken to the police station for interrogation, where he told the investigator, "I killed my mom because she poisoned me." That was not true. He was delusional in that regard. This case points out the myriad problems that come with trying a case involving someone who is just not mentally right. You are applying the standards of decency and conduct that would apply to all of us in a civil society, but people with this kind of mental health problem, they just don't grasp that. And they really are to be pitied, I think. I mean, I feel bad for his mom being stabbed to death over 50 times. But by the same token, this guy, the electricity that goes through his brain is not like the electricity that goes through all of ours. It goes through it in a weird pattern, and it causes him to think in a way that just does not mesh with a civil society. Now, you can be upset with him and you can put him in prison where he will himself be abused and probably have a very awful life, or you can take the more humane approach and put him into a mental institution where hopefully he will get the counseling and the treatment and that sort of thing that he needs, and hopefully he will never be allowed to be out, because when he was out, he often refused to take his medicine, and he was under control when he took his medicine, but when he didn't take his medicine, he wasn't under control. And so you want him in a controlled environment where he's always going to get his medicine and be somebody who can live, at least, if not in peace, at least in harmony with most of the other people in that mental institution. But that wasn't the tack that Georgia took. They took him to trial and they wanted to put him in prison because I think for the most part, the barbarity of the crime spoke to the police officers about a need for punishment as opposed to a need for treatment. So they charged him with 3 crimes: murder, felony murder, and aggravated assault. At trial, he did not dispute that he killed Diane, but asserted an insanity defense. Under Georgia law, a jury may find a criminal defendant not guilty by reason of insanity if, at the time of the crime, he did not have mental capacity to distinguish between right and wrong, or he committed the crime because of a delusional compulsion to act which overmastered his will to resist committing the crime. Such a verdict results in the defendant's commitment to a state mental health facility until a court determines that release is appropriate. Even if a defendant fails to prove an insanity defense, a jury may still render a verdict of guilty but mentally ill, under which the State Department of Corrections may, at its discretion, refer a defendant for temporary mental health treatment. The jury returned a split verdict. McElrath appealed. It isn't really clear in the opinion about how this all came down, but basically what happened was he got the acquittal on the malice murder, and then he was convicted on the other 2 crimes, aggravated assault and felony murder. When it went to the appellate court, because McElrath appealed, when it went up to the state Supreme Court, the Supreme Court found that the verdicts were repugnant to one another, and as a result, it threw out all 3 of the verdicts, and it sent it back for retrial, at which point they went back to the trial court, and in the trial court, McElrath said, hey, you can't try me for malice murder because I was acquitted, and an acquittal is an acquittal is an acquittal. And the trial court said, nah, I don't think so. We don't like that rule. We're going to go and try you again. So he appealed again, and it went up to the state Supreme Court again. And the state Supreme Court said, we are going to affirm because we think that, he should be retried on all of these matters. One of the judges on the Supreme Court of Georgia said, I'm kind of bothered by this because it appears to violate the rule against acquittals, that we can't retry somebody who's been acquitted. But given that it was a bad crime, I'll let this one go. So it goes up to the United States Supreme Court, and that's where Judge Jackson takes us. The Supreme Court of Georgia agreed with McElrath that the verdicts were repugnant. As the court explained, the not guilty by reason of insanity verdict on malice murder and the guilty but mentally ill verdict on felony murder based on aggravated assault required affirmative findings of different mental states that could not exist at the same time during the commission of those crimes as they were indicted, proved, and charged to the jury. There was no way to reconcile those verdicts because, as the court noted, the jury could not conclude the crimes occurred at different times or through distinct acts. But instead of vacating only the felony murder conviction, as McElrath had requested, the state Supreme Court vacated both the malice murder and felony murder verdicts. On remand, McElrath argued that the double jeopardy clause prevented them from retrying him for the murder, so the Supreme Court granted certiorari, and the double jeopardy clause provides that no person shall be subject to trial for the same offense and twice be put in jeopardy of life or limb. The controlling constitutional principle of the clause focuses on prohibitions against multiple trials. It has long been settled under the Fifth Amendment that a verdict of acquittal is final, ending a defendant's jeopardy, and is a bar to subsequent prosecution for the same offense. So it then says, what then is an acquittal? And it goes through that. Once rendered, a jury's verdict of acquittal is inviolate. We have described this principle that a verdict of acquittal could not be reviewed on error or otherwise as perhaps the most fundamental rule in the history of double jeopardy jurisprudence. This bright-line rule exists to preserve a jury's overriding responsibility to stand between the accused and the potentially arbitrary or abusive government that is in command of the criminal sanction. The Supreme Court recognizes that once somebody has been acquitted, they can't be retried, and that's, the history and tradition and consistent application of that bar says that. So that is essentially the holding that they present. It's a 10-page opinion, and let's take a look at what the final conclusion here is that they reach. The jury's verdict of not guilty by reason of insanity on the malice murder charge was an acquittal for purposes of double jeopardy. The clause therefore bars retrial of McElrath on that charge. The judgment of the Supreme Court is reversed and the case is remanded for further proceedings not inconsistent with this opinion. So let's look at that footnote. On remand, the Georgia courts may address as a matter of state law the status of McElrath's vacated conviction for felony murder. So there were initially 3 verdicts: not guilty by reason of insanity, and guilty but mentally ill on the felony murder and the aggravated assault. When the Georgia Supreme Court took its action and vacated the repugnant verdicts, in other words, both the acquittal and the 2 where he was found guilty, those went away. They don't exist anymore. Now, the Supreme Court has said that you cannot retry him on the malice murder. The writing on the opinions both at the Supreme Court of Georgia and the Supreme Court of the United States has been a little bit confusing. I want to make sure that I give you the full deal here. The felony murder conviction was reversed by the Georgia Supreme Court, but the aggravated assault was not reversed, apparently. Essentially, the associated verdict on the aggravated assault stands clear, and it is a valid judgment. That means that the only thing that he can be retried for, if he's retried at all, would be for the felony murder. It looked to me like initially all 3 of them were thrown out, but apparently as I read further, the only one that is subject to retrial is the felony murder conviction. Well, the state could retry him, or the state could come back and say, we know he's going to be in the state mental institution for the rest of his life, because when somebody is found guilty by reason of insanity, they have to go into treatment, and this guy has such an awful case of mental illness that it's unlikely he will ever see the light of day as a free man again, because he can't live in society. He can't live in civil society because his brain doesn't work the way everybody else's brain does. It's a tragedy, really. Obviously, there are a number of considerations, including the safety of the public, that should keep this person under some level of governmental control, probably for the rest of his life. The question just becomes whether or not to retry him on those and then have it set up where, if for some reason he is able to convince the doctors at the state mental institution to let him out, then he has to go back to the state prison because he has life sentences for felony murder and aggravated assault. Hard to tell what the state is going to do on that. If I were the state prosecutor, I would probably leave well enough alone. They've spent enough money on this case already. Let him stay in the mental hospital for the rest of his life. But who knows what will happen. Now let's take a look at Judge Alito's concurrence. I join the opinion of the court, but write to clarify my understanding of what we've held. In this case, there was indisputably an acquittal on malice murder. The jury returned a not guilty verdict on that count. The trial judge entered a judgment of acquittal on that count, and the petitioner appealed part of the judgment. Because the Constitution does not permit appellate review of an acquittal, the state Supreme Court's decision must be reversed. As I understand it, our holding extends no further. As the court recognizes, the situation here is different from one in which the trial judge refuses to accept inconsistent verdicts and then sends the jury back to deliberate further. Some states follow this practice, and Missouri is one of them. I actually had that happen in a case involving sexual harassment, where the jury returned verdicts that were inconsistent, and the judge said, "Jury, your verdicts are inconsistent. You have to harmonize them," and sent them back. Didn't give them a whole lot of explanation, but essentially sent them back and said, "You have to do this again," and that time they got it right. So essentially, that's not a matter of federal law, that's a matter of state law, where you get an inconsistent verdict, but the jury gets re-empowered to make another determination. That's not going to be covered by this case. So that's what I have for you today. If you have any questions, you can leave them in the comments down below, or you can email me. I would appreciate it if you would take some time today and do something nice for someone. Do an act of kindness. Those always make you feel better. Have a great day, and catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.